I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame. Today we are jumping into Compilation 107. We're going to be in 4 different judges' courtrooms for this compilation. Don't forget to like, share, comment, and subscribe. There will be no commentary added to this compilation, of course, and there will be chapters added for all of you guys' convenience. Now, the first judge's courtroom that we will be in will be that of Judge Rocky Coss out of the state of Ohio. Second, we will be in the courtroom of Judge Bryant out of the state of Michigan. Third, we will be in the courtroom of Judge Andrew Wheeler out of the state of Washington. And last but not least, we will be in the courtroom of Judge Donald Coleman, also out of the state of Michigan. Listen, guys, been having a lot of fun with these compilations. And with everything that you guys have been saying in the comments has been great. I appreciate the feedback. It's been a blessing. And listen, nothing else to be said, but let's go ahead and jump into number 107.
All right, this is case number 24 CR 137, State of Ohio versus Brian Keith Taylor. Are you Brian Keith Taylor appearing there from the jail?
Yes, sir. Yes, Your Honor.
All right.
Okay.
Just a minute. Be quiet. This is case number 24 CR 137, State of Ohio versus Brian Keith Taylor. This is a pretrial being conducted by Zoom. The defendant's been indicted on 3 counts of aggravated trafficking and 3 counts of aggravated possession of methamphetamine. Mr. Taylor's attorney is Dennis Kirk, appearing from his office, appearing from the prosecutor's office, Prosecutor Collins. This is a final pretrial. I believe we have a trial date set for April the 7th. Now, I believe that discovery was filed. There's no, Mr. Kirk, did you file a compliance with discovery?
I did, Your Honor.
Okay. Well, we pulled these files last week, so we, actually I see over here there's a red jacket. I see them. Yeah, okay. And then it looks like the state filed an additional discovery this morning with a lab report on it. And you received that?
I did receive that. Yes, my client's not yet aware of it, but I will take that out to him.
All right. And I don't see any pretrial motions filed, or did you file any?
I did not.
All right.
I did not see the warrant for any, so I did not file any.
All right. Now, what's the status of the case then in terms, I know we have a trial set on the April 7th, so that's actually inside the 14-day window, but I believe that this was the best we could do on the scheduling date. So what's the situation here with this case, counsel?
It's protected.
I have made my client aware of his plea offer. We did actually negotiate on that. I have made him aware of the 14-day rule. Also, the form to basically I forget what the technical term for it is, but basically the plea refusal form, gone over that with him as well. He does not wish to sign that form, but has not necessarily stated he wants a jury trial either. He did want me to go back to the state with some additional things, which I did, and they declined to change the offer. So at this point in time, I'm not sure what he wants to do. He's never given me a clear answer.
So, Mr. Taylor, is that are you rejecting the plea offer the state made and electing to go to trial? Is that your decision?
The process, this process here, this pretrial hearing, I got motions. I'd like to file.
Well, you're not representing yourself. You have an attorney. And so,
I know that.
Well, wait a minute. Just wait a minute. I'm going to address this. And under the rule, motions, if you have an attorney, only your attorney can file a motion. So if you prepare something that you want to file, I have ordered our clerk's office not to accept those. They will not accept them because you are not representing yourself. The only way you can file a motion is if you represent yourself, in which case that would be a huge mistake. And you haven't asked for that, and there's be quiet, don't interrupt me when I'm speaking. I'll give you the chance to talk. You just be patient and listen, okay? One of your problems may be that you want to speak instead of listen, and that's a big mistake too. So, getting back to my point is that, there's not what's called a hybrid representation system in Ohio, and that's a criminal case. The defendants can't file their own motions. Now, your attorney's indicated that he has reviewed with you and didn't find anything that had any legal merit, that arguable merit that he could file. And under the rules of law, attorneys aren't permitted to file frivolous motions just because their clients think they should. They're the attorneys. They're the ones that know the law. They're the ones that know the rules of professional conduct. They're the ones that are bound by it, not a defendant who wants to file any kind of number of motions based probably on what you've seen on TV or in the movies, which is, again, a real big mistake to believe that kind of crap. So that's where we're at. Now, going back to my question, are you rejecting the plea offer?
Yeah.
Yes? Okay, then we will have a trial on April the 7th. All right, so does the state expect this to take more than 1 day?
No, the state expects this to be finished in 1 day.
Okay. And you agree with that, Mr. Kirk?
I would agree with that, and I would note just for the record, I've been given no names, addresses, phone numbers of any witnesses, so I don't think we'll have very many, if no witnesses at all.
Well, if there's going to be any witnesses, Mr. Taylor, you have to give those to your attorney so that he can file and respond. Those will due by today, so if you've got them, get it to him right away so he can give them to the state. I'll give you till tomorrow to do that. Now, anything else that we need to discuss in this case?
Yeah, I want to ask to have my attorney removed, and I got grounds here. I asked him to file a few motions which are legitimate. I mean, this ain't from TV, this is from going through the law book and studying day in and day out. Everything I got the case numbers, case laws, I got.
Motion, what kind of motions are you talking about, Mr. Taylor?
But one is a motion to suppress. I got one here, it's a
motion to suppress, but this is I believe this is a undercover buy situation, isn't it?
It is 3 buys.
Okay, so I don't know what kind of motion to suppress would be appropriate. What do you think could be suppressed?
It'd be.
Well, if you know so much about the law, you should be able to answer that question. I've got an attorney here who knows the law and tells me there's no basis. And now I've got you telling me there is, and I ask you what it is, and you can't tell me.
I asked you to file the motion.
I know that. I'm saying is, what is it you think should be suppressed and why? What's the legal basis for it that you, being a non-lawyer, has come up with that an accomplished lawyer has not?
That's on my paperwork here. None of you organized here at the same time.
So you have an answer. What is it you would seek to suppress?
I don't know.
Pardon me?
I don't know.
You don't know? Okay. Anything else you want to bring up?
I'd like to have my attorney move from the case and have another one, please.
Wait a minute. I'm having trouble understanding you. I can hear you.
I'd like to remove my attorney and get another one.
Okay. Well, you have until April 7th to get yourself a new attorney. If you want to get a new attorney, you can do that. You'll have to hire them because you didn't hire Mr. Kirk. You didn't have the money to hire an attorney, so I appointed him for you. So he's your attorney unless you get a new attorney. But if you do, they need to be ready to go to trial on April the 7th.
I can't get another court-appointed attorney. I can't afford an attorney.
No, you have a court-appointed attorney. I've given you a court-appointed attorney.
But he's not representing me.
Yeah, he is. He's representing you, and he's had conversations with you and discussions. You don't like what he's telling you. I get that. If I were in your position, unless they were telling me you're going to walk free and the state's going to give you a written apology and $1 million, I wouldn't be happy either. But, he's not going to do that. So, unless you can tell me why he is not, he shouldn't be your attorney, then you've given me no reason other than the fact that you don't like what he's saying and he won't file motions that aren't proper, which is no attorney would file. So getting you a new attorney would not mean anything because a new attorney wouldn't be able to file frivolous motions either. And if I gave you any attorney who knows what they're doing, they're not going to do anything different than Mr. Kirk is. Mr. Kirk's been doing this a long time. Now, anything else you want to bring up?
Yes, I have grounds, man.
I asked you what your grounds were, and you didn't tell me anything. You said you didn't know on suppression.
I'm be respectful. Wait till you're done talking.
I'm sorry, what?
Don't be respectful, man. Wait till you're done talking. You got only once for interrupting.
Okay? I asked you to answer my question and you didn't when I asked you what your grounds were. Now, I'm not going to give you another attorney. If you want to get a new attorney, that's up to you. You feel free to do that. You'll have to hire that attorney. But I don't know who told you that you're entitled to get more than one attorney because the court has appointed you an attorney. Mr. Kirk is qualified and competent and experienced and knows way more than you'll ever know about the law. So just because you've been in court a few times doesn't mean you know anything about the law. Just because you got a book you can read doesn't mean you know anything about the law. I could read a book on brain surgery, but that wouldn't make me a brain surgeon. You can read a book on the law, it ain't going to make you a lawyer. Now, any other things you want to bring up, Mr. Taylor?
Represent myself.
Well, that would be the biggest mistake you've ever made in your entire life. Based upon what you've been telling me, I don't think there's any way in the world you could represent yourself. Pardon me?
I haven't been able to tell you nothing.
I can't understand your mumbling.
I haven't been able to tell you anything.
Well, you're not the attorney. You're on trial. You don't get to participate in your defense because that's what an attorney is for. That's why you have one.
But am I allowed to have a fair and just defense?
Oh, absolutely, and that's what you're going to get. We'll have a fair trial. We'll have a jury, and we'll have a trial.
I don't have all my discovery. I'm missing 12 things that I'm not discovered. I'm begging for.
Well, he's got the discovery. Let me explain here, Mr. Taylor. I met with your attorney and the prosecutors before this hearing, and he kind of outlined to me some of the things you're talking about. As I understand it, you have everything of any importance. I think he said you had mentioned that you didn't have a copy of the resume of the BCI analyst or something, which is minor. It doesn't mean much. He can get that to you. He will get that to you. But the other things that you want, my understanding, he's given you more than what most defendants get in these kind of cases because usually there's a counsel-only discovery restriction. But since the identity of the CI is known, apparently they have let you watch the videos, right? You've watched the videos of the what they say are the buys, right? And then you've gotten copies of everything that he has, pretty much. Is that correct, Mr. Kirk?
That is correct, yes.
All right, so I don't know what you're talking about when you say you don't have discovery because you've got everything that he's got. And that's it. Discovery is what he's giving you what he has.
My discoveries don't even have counsel eyes only stamped on them.
It doesn't have to have a stamp on it. It's done by email.
And same time, I get a piece 1 week, I get a piece 2 weeks later, and I get a piece Monday.
All right. Well, good. It gives you something to do. So what? We still got 10 or 12 days to try. But again, you're not going to be the one that's going to be questioning the witnesses and presenting evidence and making arguments. That's what your attorney does. Pardon me?
Well, I'm afraid of.
I would be afraid too if I were on trial, but that's not why we're here. This is a final pretrial, and we're ready to go to trial. With the court, we're going to send out our jury notices today. State's ready to go, and you're going to be ready to go unless you get a new attorney. And again, you're not going to get maybe you can find somebody to be willing to take the case and go to trial on the 7th. But that's going to be on you. If you want another attorney, you can get one. But all this stuff you're telling me doesn't amount to a hill of beans, as my dad would say.
I represent myself.
Pardon me?
I represent myself.
Well, if you want to do that, how are you going to do that? What do you know about the law?
I don't know that much about the law.
And so you want to go to trial not knowing much about the law against a prosecutor that does know the law?
I think my percentages would be higher, yes.
Pardon me?
I think I would have, my percentages would be higher, yes.
Well, I can't understand what he's saying.
Yeah.
He said his percentage would be higher. His percentage of winning would be higher if he.
Oh yeah, what do you think that would be?
I don't know.
Well, give me the odds. I'll take that bet. Because you're absolutely 100% wrong. Everything you're saying here is exposing the stupidity of your position. And for me to allow you to represent yourself will be guaranteeing you a conviction. You'd be getting convicted of everything. You don't know what you're talking about. Have you ever picked, do you know what the word voir dire means? Okay. Yeah, do you know what the separation of witnesses is?
That's one of my motions to seven.
Well, we don't get, no, separation of witnesses, I ask you.
Yes, yes.
What is, okay. So what is it?
Five.
Huh?
Motion I asked him to file.
Okay, well, that is filed at the time of the trial. When we start the trial, that's an oral motion. What kind of a motion did you want him to file?
You have to give me time to get it.
No, you're the one that claims to know more than he does. You should have been prepared to tell me. If you've got all these arguments, don't tell me you got to sit there and try to figure this out, because we're not going to sit here all afternoon. You tell me what it is you wanted him to file. You just told me you wanted him to file something. Tell me what it is you wanted him to file. Don't tell me you got to go look for it.
I'm pretty organized here.
Well, why can't you answer the question then?
Because I can't tell you without.
Okay, well, look at it. You should be able to find it. I'll give you 15 seconds. Find it.
File a motion for the rest of my discovery.
There is no other discovery to file to get. You cannot. Pardon me?
I got a list here.
What?
I think he's basing his list off of other people.
No, I'm not.
Because he thinks there's a set number. Sir, he thinks
Be quiet. Let me hear what Mr. Kirk's saying. Go ahead.
He thinks there's a set number of discovery items. I've told him that is a myth. Some people may have 14. Some people may have 2. And I've explained that to him. However, he does not trust my advice on that. I do not believe he's missing anything other than there is a lab report that was just filed that I will be taking out to him. But he thinks there's some sort of mythical set number of items.
Okay.
Judge, I can probably shed some light on this as well.
Go ahead. No, would like to.
Some defendants believe that they should have copies of the buy money, for example. In this particular defendant's case, those are actually pictures that were on the digital evidence that he would not have access to out there because he's in jail.
Right, I understand.
There are several things that are digital evidence that he physically cannot have access to because he's in jail.
Okay. Well, your attorney has those, and he's shown them to you, as I understand it, right?
Yes, he showed me the digital stuff. But he has showed me, yes, right. But also, if they're going to have PCI experts on the stand, and we get a chance to cross-examine them, shouldn't I have their qualifications and all that for cross-examination? Also,
Cross-examination would be based upon their report.
Also, the submission report to the PCI lab, I don't have, and I don't have the physical evidence or the witness. I got the witness list. I don't have the CI's felony report. I don't have the forfeitures. I don't have disclosure of all evidence and everything from them.
Well, your attorney has it, and he has it, and he's discussed it with you. You don't have to have all that with you in jail. I don't know that you'd have room for it. So, Ms.
Doesn't exist.
Pardon me?
A lot of this that he's talking, so he just said he doesn't have a list of the forfeitures. There are no forfeitures in this case.
Oh,
he
well,
has
there would
the
be. Yeah.
CI's. He has the CI's criminal history. He just doesn't know how to read the discovery. We provide the CI's.
Okay. So,
CA
Right here, John. Right
He
here,
doesn't
my
understand
bill
the
of
read.
right? Correct? This right here is a signed paper that's the end of my particulars. That right there, my daughter needed a commission slip to go to school. I can put this on it. That there says that goes to a bill of particulars. There's no date, no stamp, no nothing on my bill of particulars.
all right, well, I don't really, it really doesn't matter. It's immaterial. You have copies of what is filed, and that's what's important.
I can answer this too.
Legal process.
All right, wait a minute.
I can answer this too. We don't file a bill of particulars in court because it names so much protected information.
Right.
We file a notice of filing. The
Right.
bill of particular, The bill of particulars doesn't get stamped or anything like that. It's secret.
I understand, but it still has to have some type, some more, because it can be reproduced. Everything I got can be.
Okay, well, again, you're operating from a complete ignorance of what's going on here. As she indicated, the bill of particulars does not have to be filed with a file stamp in the public file. And in fact, oftentimes it's not, because it names people that are to be remain confidential. And in some cases, we've had a situation where the paper picks it up and prints it all before the trial, and then that person had all that information is out there that could potentially prejudice the defendant. And so your complaint about it not being file stamped, it means nothing. That is a big fat zero that means nothing. You have a copy of it, and that's all you need.
Criminal Rule 16C says that it has to be prominently stamped, counsel eyes only. And everything they gave me.
Well, it's not stamped cancel eyes only. You've got everything in this case. Now, I'm not going to argue with you anymore. All right? The bottom line is, what you're saying is all without any legal merit whatsoever, because you've read a book and you think these things say this and that, and they don't. And you're not entitled to stuff that doesn't exist. You don't have to have stuff that doesn't have to be file stamped, and nothing that you've told me means has any legal significance at all. It seems to me that what you ought to be doing is focus on the allegations in this case and the evidence that you do have in this case, which is apparently some videos or audios and witness statements and people who are going to testify. That's the stuff you need to be focusing on, not on a whole bunch of stuff that you think you should get that you're not, that either one doesn't exist or two is you have it and you don't understand it, and that's your fault. And that's just, again, the fact that you don't know what you're talking about. That means
everything.
Pardon me?
I brought so much to my lawyer, and he has dismissed and excused everything. I got this form smoking crack in the video, but he dismisses it, justifies it. It says I'm smoking a pipe, and nowhere in the video I'm smoking a pipe, but he dismisses it and justifies it.
Well, it'll be in the trial. I mean, if it, whatever the videos show, they show. I don't know what's on there. This isn't about that. We're not going to argue about that. Whatever the evidence shows will be what is going to be introduced at trial if we're going to have a trial. And it sounds like that's what you want. So if you want to have a trial, that is completely fine. We're going to go ahead and send out a jury notice here this afternoon, and we'll summons in the jurors, and we will see you on April the 7th. Again, if you want to represent yourself, again, I would tell you that would be a big mistake. But if you want to file that motion, I will have a hearing on it and give you the opportunity. But I can tell you that you will absolutely have no chance in the world at a trial based upon your performance here today. Because just because you represent yourself doesn't mean you get to bring up everything that your attorney says you can't. Because if he says you can't do it, and he's right, which I'm guessing that he is, because he's been around the block a few times and tried cases in this court, then you're not going to be able to bring it up. And so when you're being upset with him not bringing up stuff you want him to, when he tells you you can't, it's not admissible, that's going to be the ruling of the court. And, most likely what will happen is, you're going to come in here thinking you can do this and that, and you can't, and I won't let you. You'll end up hardly having anything to say on your own behalf. You're not the first person I've dealt with that's represented themselves, or wants to represent themselves. And if you want to do that, you can file a motion. There's a hearing I'll have to go through and ask you a whole bunch of questions that will point out, what a big mistake that is. You'll still have to have a legal advisor to stand by to answer questions for you at the trial. They won't be able to participate, and we won't start the trial you representing yourself and then deciding, coming to your senses and finally realizing you've made a big mistake and then say, okay, Mr. Kirk, I'm in over my head, take over. That's not the way it works. Once you start it, you're going to finish it. Again, under the law, unfortunately, the court is not permitted to protect the biggest right that a defendant ought to have, which is the right not to be stupid. Unfortunately, you do have the right to be stupid, and you can exercise that at any time. And if you exercise that by representing yourself, that will be the biggest mistake you've ever made. I'm just telling you that. I can tell right now that you're not going to be able to effectively represent yourself. But if you want to, once we go, just be quiet, I'm explaining. If you want to file that motion, that's one motion I'll permit you to file on your own. We'll have a hearing on that, and we'll go through all those requirements I'm going to have to do. I'm done with you now because I've got other cases I need to move on to. This is a pre-trial, not a trial, and I'll make that ruling. And so if you want to do that, I'll have a hearing on that, maybe Monday, and that'll give, and we'll see what's going to happen. Again, I'm telling you, do not try to represent yourself. And because, when you said your odds will be better, they'll be infinitesimally worse. They'll be so much, so bad that you can't even imagine it. And again, these cases, in cases like this where, you need to focus on what the evidence is as opposed to what you think the attorney is or isn't doing. That's the issue. Look at the evidence that you do have. What is the evidence against you that the state says they're going to present? And then make your decision based upon that. And as far as asking for stuff that's not out there, or stuff that you can't have in jail because it's digital, and your attorney has shown you those things, you have everything that the state has. There's nothing more they can give you. And so, you could file 135,000 motions asking for more discovery. If there's nothing more to give you, they're not going to be granted, So, what you're asking for is stuff that you apparently think you know about that you don't. And again, I don't know where you come up with these 14 items of discovery, but to the extent that you're getting advice from people that are in jail, think about, how smart they are if they're where you are.
Every idea I'm getting is coming from the Criminal Handbook 2018, and everything comes out of it that I've got.
You've got everything you're supposed to get. That means the criminal law book doesn't create things. It just tells you what you're entitled to. The state has provided all that. Your attorney has got it. He has shown you everything, other than this last lab report, which just came in, and he's going to give that to you. He just got it today. So, you have it. There's nothing that you are entitled to have or can have that you don't have. So, I don't know. I don't know what else to say. So, all right. Now, we're done. Anything else from counsel?
No, Your Honor.
All right.
No, you're on.
All right. Thank you.
There's a lot of distracted defendants this morning. And if we're not going to be able to come to court appropriately on Zoom, we're going to have to come in person. So I'm going to attempt this. I'm going to attempt to do Mr. Harris's case. But Mr. Harris has 2 and 3 devices. He keeps putting his fingers and stuff up to the camera. I'm not going to be able to do it. So if Mr. Harris is not going to be able to be stationary, seated in an upright position, and not keep putting his fingers and stuff in the camera, he's going to have to come in person. This is case number 234579701, the people of the state of Michigan versus Michael Eric Harris. The defendant is charged with 1 count of driving while license suspended, revoked, denied, 1 count of security fail, and 1 count of unregistered motor vehicle. Today is the date set for pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
And yes, Your Honor, Brandon Bird on behalf of Michael Harris. Mr. Harris, can you please unmute yourself and state your full name for the record?
Greetings. This is Harris Michael Eric, authorized representative of Michael Eric Harris.
I only want Michael Eric Harris. I don't want any authorized representative. The law indicates that there is no authorized representative on behalf of the person. If Michael Harris is not present, then the person who's holding up those papers should not have come to court. So I'm going to go ahead and remove them, or I put them back in the breakout room. You can find out if this is Michael Harris. If it is not Michael Eric Harris, I don't want to speak to him. I am not going to conduct court with anyone other than Michael Eric Harris. So this person can go back to the breakout room and you can find out if this is Michael Harris. If it's not, then they're free to go. This person who is free to go, who is holding up papers saying he's not Michael Harris, is free to go if he's not Michael Harris. All right, okay, I'm ready to recall case number 234579701, the People versus Michael Eric Harris. The defendant is charged with driving while license suspended, revoked, denied, operating an unregistered motor vehicle, and security fail, which is no insurance. Appearances again, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Yes, Your Honor. Brandon Bird on behalf of Michael Harris. Mr. Harris, can you please unmute yourself and state your full name for the record?
Michael Eric Harris.
Today is the day set for a pretrial conference. How are we proceeding?
We'd like to set this matter for a final pretrial, Your Honor.
Court is going to continue a not guilty plea on behalf of Mr. Harris and set the matter for a final pretrial conference. This is basically a traffic case though. So I wasn't ordering discovery. Is there any really discovery? I wasn't ordering discovery. This is like one of those cases that state police wasted a whole bunch of paper instead of writing tickets.
So, Your Honor, it looks like there is some paper discovery. I'll just check the IR to see if there's any body or video discovery, and if so, I'll send that over to Stevenson and or Mr. Bird.
All right, so the court is going to set the final pretrial conference. Let's go ahead and, well, is the April 16th date a good enough time for you to do that, Ms. Ritter?
Yep, Judge, I just sent paper and I just looked, there is video, so I'll send that over today.
All right, then the court is going to set final pretrial conference for April 16th at 9:00 a.m. and she just sent discovery, Mr. Bird. So if there's any video, or I think she said there is video, so she'll send that as well.
All right,
Okay.
Thank you.
Have a beautiful day. Hello. Okay, sir. Yeah. So, well, we're here for readiness. Ms. Carmi, this is Mr. Duggar. He's
Yes.
scheduled for court for trial on the 26th.
Yes, I did have a chance to talk to Mr. Duggar. He is indicating an intent to move forward with trial.
Okay.
He is requesting a jury trial.
Okay.
I did in order to kind of narrow what our issues were, I did speak with him about that, and perhaps I would like him to discuss that with you. I think there is a divergence of less factual and more legal that he plans to argue.
There's facts and legal.
I know, and that's why I don't want to put words in his mouth. So I guess I'll let him tell you what his issues for trial are.
Okay. You want to do it right now on the record?
It's up to you, Your Honor.
My issues are all constitutional and they're all facts.
Here's my concern, Your Honor.
Supreme Court decided facts. Excuse me. I'm sorry.
He is asking for a jury trial. However, I believe some of his argument, most of the argument, is a question of law only. And that is whether he is required to have a driver's license.
Okay. Yeah.
So that's why I am trying to strike a balance here with what he wants, with what the court procedure would be if it purely is a question of law. That would not be for the jury to decide.
Yeah.
Question rights.
No, I understand. But there's no argument about whether or not he has a license. We all agree on that.
I don't have one. Don't want one.
Okay.
So it's
I don't want
just
the restrictions of one.
whether he has to have one. So I believe this is properly a bench trial in front of Your Honor with briefing on the constitutionality and and requirement to have a license with that statement.
Where jail time is concerned, I'm entitled to a jury trial.
So, Mr. Duggar, my recollection is that you have some matters in Clark County as well. Am I right about that?
And
or
Stevenson.
In Stevenson?
And Clark County.
Okay, so you have.
I got a trial tomorrow in Clark County.
Okay. Okay. And are you representing yourself in that trial too?
I am myself. Yes, I'm pro per.
Okay. And you want to continue to represent yourself in these matters?
I continue to be myself. Yes, sir. You know,
I enjoy the nuance of the answer of the sovereign citizen always, sir.
I'm not a
I think
citizen.
well,
There's no such thing.
well, you know, I always enjoy the nuance of how an answered question can be just twisted just a little bit. So I agree. I think Mr. Duggar has the right to have a jury trial. Certainly the city will have the ability to certainly. Mr. Duggar, have you done trials on your own before?
I did one time, a long time ago, years back.
Okay. Well, you certainly have the right to do that. You are held to a standard of understanding the rules of evidence and so forth. So right now, I am going to go through a waiver of your right to an attorney with you. Okay. And answer any questions you have. And if you want to, you can look at this before you bring it back up to me. Okay.
Incompetent. Only incompetent people need attorneys.
Oof.
Yeah, I've heard.
Oh yeah.
Man who represents itself has a fool.
So you have a right to remain silent.
Yes, sir.
Okay. So I'm going to have to I'm going to read you this waiver of right to an attorney. You're going to sign off on it. If you understand the right, you can't later come back and say you didn't have effective assistance of counsel. Okay.
You betcha.
Says, I understand I am charged with the crime indicated on the citation or complaint, that's driving while suspended in the 3rd degree. The maximum penalty is contained in Appendix A, which is 90 days in jail and a $1,000 fine. If there are minimum penalties that must be imposed if I'm found guilty, those are outlined in Appendix A, which I have received a copy. There is no minimum penalties to the charge. I have the right to have an attorney represent me in all stages of this proceeding. If I cannot afford an attorney, I have the right to request a public defender. If I qualify, an attorney will be appointed to represent me. I may be at a disadvantage if I proceed without an attorney. I'll be required to follow the laws and court rules which apply to this case or these cases. These laws and rules can be technical and complex. I may not fully understand them without an attorney. I'm aware of the dangers and disadvantages of proceeding without an attorney. However, I choose to represent myself. Knowing the risks, I waive my right to be represented by an attorney. The court has had a colloquy or discussion with me on my rights to any attorney, my desire to waive this right. No one has made any threats or promises. Get me to waive this right. I'm doing it of my own free will. I'm going to sign that you and I have read this. Do you have any questions about the waiver?
No, none. No.
That's no?
That's a no, sir.
Thank you very much.
With my email on it, if you want to shoot it over.
I'm going to date the form just today's date for you, sir. Why don't you come on up? I'm going to make sure the pen I'm going to hand you is going to work. You have a pen? Okay.
I should have.
Sounds good. So the signature is here and the printed name is there. I'll get you a copy of that. Signature there, printed name there, please. Thank you. So here's what I think we should do, Ms. Carmi, or what I'm proposing, and I'll get here from Mr. Duggar on it as well. Okay, thank you, sir. That was your pen, so you go ahead and keep that. Okay, So right back to the microphone, Mr. Duggar, for me one last time. So I'm going to get this on the record. I know Mr. Duggar is making his way all the way from Stevenson to here. I would like us to maybe do a telephone check-in. Would you be comfortable at least having the court give you a call?
If you can get through where I'm at, it's like a black hole for cell phones.
Oh.
Way out the sticks.
Okay.
But you could try. You could give it a shot.
Okay.
I have a email address that I've been checking here lately.
Okay.
If you want that.
So
I
our
don't know if it
trial date, let me just make sure for everybody. Our trial date is set for a Tuesday, the 26th. How about, could we try to do a call on Thursday, the 21st?
You can try to call or probably be easier to get hold of me through the email. Because really, you'll probably go straight to voicemail and the only way I get my calls is go up to the top of the hill and
I probably don't want you to have to climb the hill. So Ms. Carmi, my request is going to be perhaps that we do an email, if you would not mind, as an officer of the court to Mr. Duggar on November 21st, thereabouts. So check your email that day.
You betcha.
And we're just going to confirm that we're going forward with the trial on the 26th. Okay?
Okay. And then, Your Honor, we had one request, especially given the, what is a likely stipulation here to the status of the license. We have subpoenaed and will subpoena for that specific date a DOL rep, just as a backup to that potential stipulation. May they appear by Zoom? We expect the testimony to be 10 minutes or less. So having them come from Olympia doesn't seem to make sense for all parties.
Would you be comfortable with the person from the Department of Licensing testifying over Zoom?
Sure. What you're going to testify to? That I don't have a license? I don't have one.
I don't know the facts of the case, but I would make an assumption that that would be it.
Okay. Yeah, sure.
Okay. Sounds good. Mr. Duggar, paperwork at the desk by the door. Thank you for coming in today, sir.
Good morning. The 36th District Court in the state of Michigan is now in session with the Honorable Judge Donald Coleman presiding. While court is in session, there will be no talking, sleeping, chewing gum, or reading any material. Thank you.
Thank you. This is case number 23-152244. This is Javar Grayson versus Bryant Ambrose. The matter is before the court where there is an application for entry of a default judgment. The court has set the matter on in regard to that motion. Your appearance for any attorney who's appearing on either side, your appearance in first instance, please.
Thank you, Your Honor. Christopher Michaels, P83156 on behalf of Police Officer Brian Ambrose. And briefly, there was also the defendant's motion to dismiss in lieu of answer was filed. I don't know if today is the date and time for that as well.
I do have that matter that was filed with the court June the 30th and submitted to the court. So that is an issue that's before the court as well. All right, and do I have Javar Grayson on the Zoom? Say something if you hear it this time.
Yes, Your Honor. Javar Grayson representing myself.
All right, thank you, Mr. Grayson. Good morning to you as
Good morning.
well. All right, I see that there is the, let me address the issue of the application for entry of default judgment in this matter. On what basis are you saying, Mr. Grayson, that you should be entitled to entry of default judgment in this matter, sir?
Well, Your Honor, we sent documents into you stating that I'm a national, a Morris American, and this highwayman has no jurisdiction over me. And we sent that information to you, and also sent, I believe I have a court, People versus Battle as a reference in the case.
I think that you're addressing something that don't have anything to do with my question. You submitted to the court a default request. Now, on one hand, you're telling me that the court doesn't have jurisdiction. You tell me that the court doesn't have jurisdiction, and you're not sitting into the jurisdiction of the court. Then why are you filing something in this court if you believe the court doesn't have jurisdiction? You filed
I'm sorry, the jurisdiction that doesn't have jurisdiction, the 36th District Court, a traffic court, that's not pertaining to you. What I decided to do was send you basically every information to communicate what I've been doing basically in 36th District Court, as well as this procedure.
I'm not a traffic court judge. I'm a civil judge. But I don't know what are you talking about?
Yes, sir. And I understand that.
All right, Mr. Michaels, address yourself, if you will, to both issues. One is the motion for entry of default, and then secondly, which I believe these issues might collide, the motion to dismiss in lieu of filing an answer, sir. Go right ahead, sir.
Thank you, Your Honor. I did receive a copy of the request for default this week, so I had no opportunity to respond. Obviously, the city or the city law department who's representing this police officer filed its motion back in June, dismiss in lieu of an answer. So I don't believe there's any grounds whatsoever for a default judgment. The brief speaks pretty clearly on its face for why a dismissal is appropriate. There is no viable claim stated in plaintiff's original complaint, and since the defendant is was at the time and still is a police officer, he would be entitled to governmental immunity. It appears that it's some sort of dispute regarding traffic tickets or citations that were given for various matters that are currently pending in front of Judge Perkins right now. So it also appears to be some sort of collateral attack against those proceedings, which is under Michigan rules not permitted. So we would ask this court dismiss this case under any of those grounds.
Well, certainly. Let me begin with the default request. I don't see where the defendant is in default in this matter. He's responded to the complaint. Default is when a party fails to act in the judicial proceeding, in a court proceeding, failed to act when they should have acted, and that therefore the court would be required to enter their default because of their failure. Things like failure to answer the complaint or failure to file a responsive pleading. The responsive pleading that was filed in this matter was filed in June. The case was filed, looks like June the 13th, 2023. The motion was filed June the 30th. That's certainly within the time required by law to do a responsive pleading. So I don't see any basis for default. Default is what, like if the defendant did not answer or didn't file a response, then the plaintiff could move for entry of default. I don't see a basis for entry of default in this matter. No, so the motion and application for entry of default is denied. There's nothing about this case that shows that the plaintiff is in default, or for that matter, that defendant is in default on anything. Neither party is in default. The case is right where it's supposed to be, and that is that there's been a complaint filed, and then there's been a responsive pleading. That responsive pleading is a motion to dismiss in lieu of filing an answer. If the plaintiff didn't file straight, if the defendant didn't file a motion, he would have had to file an answer to the complaint. So when there's a complaint, you got to answer within a certain period of time by either filing a written answer or by filing a motion. Sometimes there's a motion for a more definite statement. Sometimes there's a motion to dismiss because the complaint is deficient or it has some legal flaw involved. This motion to dismiss in lieu of answer is filed alleging and arguing that summary disposition should be granted, or that a motion that the court should dismiss the case because there's no legal grounds, factual grounds for this case to stand on. What is this case about, Mr. Grayson, sir?
It's about a traffic, I guess is some type of traffic ticket. It started off Brian Ambrosius stopping me, and I believe I have the right to travel. It started with that. And I do understand the default judgment, what do you that you are saying and what it's pertaining to. we are still ready to proceed with the case.
What exactly is your cause of action? Because I don't think that you stated a cause of action that upon which the court could move forward with the complaint.
Well, actually, in traffic court 936 district, there's actions being taken against me as we speak. This is a current case, and 36 district court has no jurisdiction over me. That's why I decided to bring it into civil court common law. And this is a 6-month case that's still going on. So,
all right, Mr. Michael, you get the last word on your motion.
Right, yes, very briefly, there was nothing filed by plaintiff, and it does sound like he's disputing his traffic tickets in this court, which is a collateral attack, which the Michigan court rules and do not allow. So I think that's the best ground to dismiss this case, and we would ask this court.
I object, Your Honor. I'm disputing my birthright. I'm disputing my right to travel.
All right, I got it, sir. All right, that you failed to state of action upon which the court can grant relief. This case and the complaint in this matter be dismissed. It's dismissed without prejudice, meaning that if you could formulate a cause of action that is recognized in the Michigan law, then you can bring the matter if you can formulate case law or some type of law that supports your cause of action. It sounds like part of what is being said here is that as a sovereign person, you have the right to travel and et cetera, et cetera. And there is some basis for the same, but yet there is law that allows for law enforcement to stop individuals that are traveling upon the roadways. And so if that is what the cause of action is that they don't have the right to stop me, there is nothing in Michigan law that recognizes that. If, on the other hand, you find some basis to establish that that the stop was in the form of some illegal activity, harassment, some advance against your person that is not permitted under law or done under color of law, but not permitted under the Constitution, then you certainly have the right to bring an action here or in circuit court or in federal court. This case does not have any grounding to it. For that reason, the complaint is dismissed in this matter again, and the complaint is dismissed without prejudice. That would be a final order regarding this particular file. Good day to both sides. I wish you well.
I'm not threatening you. Say one more word, and that's 30 days. 30 days.